noticed. The date and time have been previously noticed, just not the link, and it appears there's no inquiries from the public as to the link, so I think we'll go forward.
Mr. Glandolf, the meeting was noticed on the website on November 6, 2020, and the agenda was posted to the website on March 4, 2021.
Yes, that was my understanding. Why I feel that the public had been noticed of the meeting time, and the link is up now. It doesn't appear there were any inquiries in the past before the meeting that somebody couldn't get on, so it seems like anybody who would be searching to get on now can get on now.
Yeah, there was one person that contacted me, and I sent the link to that person, and that person's now joined the meeting.
Okay.
Yeah, Mr. President, I guess if Laura, are you ready to record?
Yes, sir, we're going.
Okay, Mr. President, we're ready.
Very good. Thank you, Mr. Gribble. We will call the meeting to order. It is 10:10 a.m. on Tuesday, March the 9th, 2021. Ms. Bohannon, would you call the roll, please?
Fred Berry.
Here.
Anthony Harris.
Here.
Tanya Skill Haynes.
Here.
Clark McKinney.
Here.
Scotty Porsche.
Here.
Charles Rahm. Robert Shackelford.
Here.
Mr. President, all board members are here and accounted for.
Thank you. Ms. Bendell, would you please read the statement of necessity into the record for today's meeting?
Sure. I'm going to read a little bit of a different statement than I have been reading, but the Board of Funeral Directors and Embalmers is meeting by electronic means to conduct essential business as authorized by Governor Lee's Executive Order number 16 and extended by Executive Order number 78. Meeting remotely is considered a reasonable measure to protect the safety and welfare of Tennesseans while ensuring government business may continue in a manner that is open and accessible to the public. All votes by the board will be by roll call.
Thank you. We will entertain a motion to adopt the agenda for today's meeting as it's been presented.
This is Anthony. I'll make a motion.
This is Clark. I'll second.
We have a motion by Mr. Harris, a second by Mr. McKinney. Is there any further discussion? If not, Ms. Bohannon, would you please call the roll?
Fred Berry.
Yes.
Anthony Harris.
Yes.
Tanya Haynes.
Yes.
Clark McKinney.
Yes.
Scotty Porsche.
Yes.
Charles Rahm.
Yes.
Robert Shackelford.
Yes.
The motion passes.
Thank you. You have received by email minutes from our January 12th and February 9th board meetings. We will entertain a motion to approve the minutes as presented for our January the 12th, 2021 meeting or to amend them as necessary.
So moved. This is Fred.
We have a motion by Mr. Berry. Do we have a second?
This is Anthony. I'll second.
Second by Mr. Harris. Any other discussion? Not all in favor? Well, I'm sorry. It's hard to break old habits. So Ms. Bohannon, please call the roll.
Fred Berry.
Yes.
Anthony Harris.
Yes.
Tanya Haynes.
Yes.
Clark McKinney.
Yes.
Scotty Porsche.
Yes.
Charles Rahm.
Yes.
Robert Shackelford.
Yes.
The minutes have been approved for January 12th, 2021.
Thank you. Now we'll entertain a motion to approve the minutes of our February the 9th, 2021 meeting or to amend them as necessary.
This is Fred. I make a motion to accept as printed.
Have a motion by Mr. Berry to accept the minutes as presented. Do we have a second?
Scotty, I second.
Second by Mr. Porsche. Any other discussion? Not, Ms. Bohannon, please call the roll.
Fred Berry.
Yes.
Anthony Harris.
Yes.
Tanya Haynes.
Yes.
Clark McKinney.
Yes.
Scotty Porsche.
Yes.
Charles Rahm.
Yes.
Robert Shackelford.
Yes.
Mr. President, the minutes for February 9th, 2021 has passed.
Thank you. On our agenda today, we have ethics training for our board, and that will be presented by Ms. Bendel. So we'll turn that over to you.
Good morning, everyone. I will be presenting the ethics presentation along with Chief Counsel Tony. So if you have any questions at any point, feel free to ask, and hopefully he will elaborate on some of these things as he has more knowledge than me on these. I'm going to share my screen and hopefully not mess this up for everyone. Does everyone see the PowerPoint?
Yes.
Okay. So today we're going to discuss three things. We're first going to start with the Open Records Act, and then we are going to move on to the Public Meetings Act, and we're going to finish with some TDCI guidance regarding ethics. Just a small disclaimer, this information contained in this presentation is for general guidance relating to the Open Records and Public Meetings Act. The Open Records Act can be found in Tennessee Code annotated 10-7-503. What is included in the open records for a board or commission? Essentially everything. A public record includes all documents, papers, letters, maps, photography, microfilms, electronic data processing files, output films, sound recordings, or other materials, regardless of physical form or characteristics. So in terms of as you guys know, things like the legal report, those are protected under attorney-client privilege, but all other documents are subject to the Open Records Act. The next thing we're going to talk about is the Public Meetings Act, which can be found in Tennessee Code annotated 8-44-101. And these are some of the things that we're going to discuss. We're going to discuss what is the Public Meetings Act, what is a meeting and what is not a meeting, what is required for a meeting and covered by the Public Meetings Act. You need notice, you need an agenda, you need public presence, and you need minutes. And what happens if the board violates the Public Meetings Act? Essentially nullity, which sounds like it is, it's legal void. We'll see that this morning that meetings and notice are 90% of the Public Meetings Act, and really notice is something that as a day-to-day matter, the executive director, Robert, and the administrative staff, such as Lisa, take care of. So our focus is going to be on meetings. The definition of a meeting, TCA 8-44-101, the General Assembly hereby declares it to be the policy of this state that the formation of a public policy and decision is public business and shall not be conducted in secret. This means anytime you adopt a rule or you modify a rule, that's formation of public policy, and decisions, all the decisions you make here are all subject to public viewing, and they should not be conducted in secret. It further goes on to say that this part shall not be construed to limit any of the rights and privileges contained in Article 1, subsection 19 of the Constitution. And this part of the Public Meetings Act refers to the free speech clause. The way to read this is that the limitations placed on your speech and actions while serving for the board are first of all voluntary. You volunteer to serve on this board, but moreover, you should understand that the legislator is not telling you that you can or cannot say anything. But while serving as a board member, all that you should say should be on the record and accessible to the public. This act is remedial in nature. It's intended as a remedy, and it should therefore be construed broadly to promote openness and accountability in government, and to protect the public against closed-door meetings at every stage of the government body's deliberation. Every time we see the courts and judges talk about this, they will do so in expansive language because they are trying to leave no loopholes. All meetings of any governing body are declared to be public meetings open to the public at all times, except as provided by the Constitution. The previous section said that all of your policies and decisions are public business. Now it's telling you that all of your meetings are public business. So such as this board meeting today. The Public Meetings Act applies to all boards and commissions. So it applies to this funeral board. TCA 8-44-102B1A says governing body means the members of any public body which consists of 2 or more members with the authority to make decisions for a recommendation to a public body on policy or administration. The Public Meetings Act applies to every meeting of a board or commission. It further goes on to say meeting means the convening of a governing body of a public body for which quorum is required in order to make a decision or to deliberate toward a decision on any matter. Thus, committee and subcommittee meetings are also included. So in addition to those full board or commission meetings, subcommittee and committee meetings are included under this Public Meetings Act. If anyone has any questions, feel free to stop me at any point. So now we're going to talk about what is not a meeting. And a meeting does not include any on-site inspection of any project or program. There's an Attorney General opinion on this regarding jail inspectors that if you're deliberating during an inspection, then it becomes a meeting, but otherwise it would not be a meeting under this act. Typically, I don't believe this board conducts inspections with its board members, but there are other boards and commissions that do, and those would technically not fall under the Public Meetings Act. What is not a meeting? A meeting does not include a chance meeting of 2 or more members of a public body. However, no such chance meeting or informal assemblage can be used to decide or deliberate public business. So essentially, if 2 of you, more of you meet out in the public, that's not considered a meeting unless you begin to decide or deliberate matters that would come before the board or be placed before the board. Additionally, 2 or more members of a public body may share a meal together in which public business is conducted, but such discussion should not constitute deliberations. So again, 2 or more of you can go out to lunch. However, you cannot weigh arguments for or against a proposed course of action. You cannot deliberate anything that would be before the board. Additionally, lunch breaks, restroom breaks, smoke breaks, recesses between morning and afternoon sessions when we were not by WebEx, adjournments between 2 days of a multi-day meeting, those are all not a meeting, but they are also all times when board business should not be discussed. There are regular meetings and special meetings, and they count as meetings, and they are subject to the Public Meetings Act. And the only exception to this is executive sessions. Executive sessions occur when 1 or more members meet with the board's attorney and the board is under lawsuit or has been threatened with suit, and the members ask their attorney questions related to such suit. I'm not sure, Tony, if you want to elaborate on executive sessions. I know we have some new board members who have not yet been in one.
Yeah, so the executive session normally they're called. They're not called as a meeting. They're not on the meeting notice. They don't have to be on the meeting notice as an executive session because it's more of an item that is created by case law as opposed to the statute, because the statute does say that all meetings have to be open to the public. There is still the ability to have attorney-client privilege, which is what the executive session is for. So in order for the board to receive legal advice on a matter that would be a matter of litigation or potential litigation, the board members can go into, they can listen to the attorney discuss basically board business without the public being present. And it makes sense. It makes sense that there's no reason why the public should be allowed to listen to the strengths and weaknesses of a litigation case that involves the state or the board members. That would be counter to the privilege, to the attorney-client privilege, which is one that is absolute, and it cannot be. There is no law that generally breaks that or requires somebody to disclose anything that is attorney-client privilege. So we do it on a rare occasion. Mostly, you would see it in the realm of if there was a legal action against the board that was ongoing. That's how we would give updates to board members. So if board members said, well, what is the status of this case we have going on in Chancery Court or something like that, we would basically be giving the update in an executive session, and it's usually in a different location than the meeting, where the public would not even be invited or have access to. And so that's why, so that we keep that. But as part of that, what is important is that during that session, that's when the attorney provides some type of advice or update. And if there's a question, the question from the board members can go directly to the attorney, and the attorney can answer the question of the board member, and the rest of the board members can hear. What they can't do is then generally deliberate on the issue with the advice down there in the executive session. So there's kind of a fine line as to how far the discussion can go, and generally the attorney helps to keep that discussion on the subject matter that we have down there. But executive sessions are not that uncommon to have. So unless anybody has any questions about that, I'll turn it over to Liz.
Thank you, Tony. I appreciate that. It's also important to note that during an executive session, the board may not deliberate about any specific matter before it or potentially before it. That's an important piece there. And then how far does it go? The Tennessee Attorney General issued an opinion that says that oral interviews conducted by the Civil Service Commission of Maury County with persons applying for jobs within the classified service of Maury County Sheriff's Department do come within the provisions of Open Meetings Act. And why did they say this? They said this because those interviews compromise deliberation by the Civil Service Commission as to whether a given candidate should be included on the list of those eligible to hire. We're going to talk about electronic communications, and I'm going to go through some examples here. If a board member emails the chair, here's a news article, or I'd like something included on the next agenda, those are acceptable, but not something along the lines of here's a news item about one of our licensees, we should consider revocation. Another example is if a member emails the board's counsel that they have a question about the legal consequences of something the board has done, that's acceptable. But it's not acceptable to say something along the lines of I've taken an action as a board member and now someone is upset. So these are pretty far each way. So they should be pretty straightforward here. Another example is if a board member emails another board member something along the lines, if you send an email to pick up the phone to call another board member, that's not a chance meeting. And even if you don't discuss board business, it gives a strong appearance of impropriety, and for safety's sake, it ought to be avoided here. The act should be construed most favorably to the public and is all-encompassing and applies to every meeting of a governing body except where the statute on its face excludes its application. Here again, we're going to see the breadth of the language. Now that the exclusion has to do with public the case up there has to do with public fiscal issues, but essentially this act is construed as broadly as it could be. Additionally, the public has the right to attend and observe our meetings, as we all know, and they necessarily do not have the right to participate. However, allowing public members to the opportunity to comment is positive for the board, so long as it does not interrupt the progress of the meeting. Now we're going to talk about notice. What do you actually have to do under the Public Meetings Act? There is a three-pronged test for adequate public notice. The first prong is that the contents of the notice must be reasonably describe the purpose of the meeting or the proposed action to be taken. The second prong is that notice must be posted at a time that's sufficiently in advance of the actual meeting in order to give citizens both an opportunity to become aware of and to attend the meeting. And the last prong is that notice must be posted in a location where a member of the community could become aware of such notice. The three usual methods are usually internet, newspaper, and bill posting. Our usual practice is to publish the notice of the meetings on the board's website and the department's website. And we typically post notice of the board meeting. I believe for this board meeting, we had notice back in November of 2020, and then we posted the agenda about a week ago. And as you can see, Tennessee Attorney General Opinion just 00-09 discusses the adequacy of various media for advertising the notice when trying to meet the location of the notice. There are some other state departments and municipalities that have a requirement that the notice of a meeting be published in a newspaper for general circulation. We don't have that requirement, but that is something to note that other departments do have that. The three-pronged test asks whether public notice is adequate is an all facts and circumstances analysis, and no single factor is positive. This means that all three parts are equally important. And what happens if we do not follow the Public Meetings Act? Like I said, it's nullity. It means that our actions are legally void. And the practical impact of that is that it substantially costs quite a bit of money, and that those fees are assessed against the annual operating budget of the board. So to summarize everything that we've just discussed, the Public Meetings Act is designed to make sure all board's business is conducted in a way that's accessible to the public. It applies to both you as a board member, and it also applies to the board collectively. All gatherings of more than one member are considered meetings, and they are covered by the Act. And this includes regular, special, emergency meetings, and also includes those committee and subcommittee meetings. Like Tony discussed, the only exception is that executive session, which is your opportunity to ask me any questions. You cannot deliberate or decide during that. And for every meeting, you must give adequate public notice. That means in content, location, and time. In a nutshell, if you violate the law, any violative actions are void, and the cost of litigation can be assessed against the board, which is not something the board wants. The last thing I'm going to cover is some department guidance. This was found in your TDCI Code of Ethics that you all received when you became board members. I'm just going to cover some important parts of it. The first part I'm going to cover is protected class. We have to remember that certain sensitive topics are not appropriate for public discussion. And those topics include protected class, such as gender, race, color, national origin, and religion, or other sensitive topics such as marital status, children, creed, sexual orientation, religion, disabilities, and health conditions. Communication with the public. A licensee or consumer may approach the board member with requests or information concerning the board. And it's very important to avoid engaging in discussion and refer all concerns to the board director or attorney. So anytime a member of the public approaches you, it's important to not discuss with them and let both Robert and myself know. Board members should be sure to remind the public that any statement made during or outside of a board meeting does not result in a collective action by the board and does not hold authority. In addition to the conflicts of interest statement, which you all provide annually, it's important to disclose any new information as soon as practicable. So impropriety. Each board member shall avoid any action, whether or not specifically prohibited by statute or regulation, which might result in or create the appearance of impropriety. This includes using public office for private gain, giving preferential treatment to any person, impeding government efficiency or economy, losing complete independence or impartiality, making a government decision outside of official channels, or affecting adversely the confidence of the public and the integrity of the government. No board member shall directly or indirectly use, disclose, or allow the use of official confidential information obtained through or in connection with his or her appointment for private interest or personal profit of any person. Board members should also avoid all known conflicts of interest in connection with any matter brought before the board to the extent that the member becomes aware of the conflict of interest. Additionally, regarding professional organizations, a member shall not serve as an officer or otherwise serve in a public policy-making role in any trade or professional association directly related to the trade or profession regulated by the board in which the member is appointed. And to finish, communication with board members, discuss, deliberate, and decide everything on the record. Do not discuss board business outside of the official board meetings via writing, telephone, electronic communication, in-person interactions, or through any other method of communication. Everything should be in the sunshine. Does anybody have any questions? Or Tony, do you have any additional information you would like to let the board know?
No, this time. Thank you. Thank you, Lou.
Thank you, Ms. Bendale.
No problem. Everyone has my contact information if you have any questions after this, and I'm gonna try to stop sharing my PowerPoint now.
The next item on the agenda is the legal report. So, Ms. Bendale, if you'll catch your breath and you can begin again.
Okay. Okay, looking at the legal report, item number 1 is complaint 2020-08-9341 against a funeral establishment with disciplinary history. This was a consumer complaint alleging unprofessional and deceptive conduct. Specifically, the consumer alleged that their signature was forged on an assignment of proceeds of insurance, along with their social security number, date of birth, and phone number. The respondent did provide a response to the complaint, and they denied all the allegations. And the complainant did provide a rebuttal. This complaint was sent for investigation based on the allegations. And in February 2021, a board field investigator interviewed and obtained documents from the various parties involved, and no violations were found. It's legal's recommendation to close this complaint.
This is Fred. I move that we accept the recommendation for closure.
We have a motion by Mr. Berry to accept council's recommendation. Do we have a second?
This Tanya, I'll second.
Second by Ms. Haynes. Any further discussion? If not, Ms. Bohannon, please call the roll.
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Rom,
Yes.
Robert Shackelford.
Yes,
Mr. President, the motion passes.
thank you.
Item number 2 is complaint 2020-09-2001 against a funeral establishment with disciplinary history from 2015. This was a complaint from a licensed funeral director. The complaint alleged that the respondent carries a license at a location that is no longer in business. The complainant further indicated that they were informed that the building is sold, but that the respondent is still in business and meeting with families virtually. The respondent did respond to the complaint, and they indicated that they are in the process of moving their physical location. The respondent stated that due to the pandemic and a misunderstanding with the city, the process has been delayed. The establishment signed a commercial lease agreement effective March 30th, 2020, and moved their location without any notification to the board office until filing an application for a change of location on February 12th, 2021, which was subsequent to the complaint filed on November 30th. Per core, all the paperwork and fees for the location change has been submitted at this time. It's legal's recommendation to authorize for a formal hearing and authorize for a consent order with a $1,000 civil penalty.
Ms. Bendale, did they actually perform some services during that time?
I believe they did. Robert, I'm not sure if you can speak further on that, but I believe they did. I believe they were meeting with families virtually while they were in the process of changing their physical location.
That's my understanding as well.
I'll make a motion to approve.
All right, we have a motion to approve. Was that Mr. Porsche? I'm sorry.
That was Clark.
Oh, okay.
I'll make a second.
We have a motion and a second. Any further discussion? If not, Ms. Bohannon, please call the roll.
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Rom,
Yes.
Robert Shackelford.
Yes,
Mr. President, the motion passes.
thank you.
Item number 3 is complaint 2020-09-4421 against a funeral establishment with no disciplinary history. This was a consumer complaint alleging unprofessional conduct by the respondent establishment. The consumer stated that they were named the executor of their grandfather's estate, and the consumer stated that the respondent establishment failed to provide her with any information or documentation. The consumer stated that the respondent provided information that the consumer's father instead of providing the information to her. The consumer further stated that they were treated poorly and talked down to by the respondent's employees. The respondent did respond to this complaint, and they indicated the following: that the respondent had discussed the wishes of the deceased prior to his passing and executed the services in accordance with those wishes. That the respondent worked with the deceased son because at the time of the services, the deceased wife was hospitalized with COVID. That the respondent stated that they were never presented with any legal documents from the consumer that would have put the consumer in charge of services. That the respondent provided all of the requested documentation to the consumer, and the respondent denied the allegations that the respondent's staff was unprofessional. It's legal's recommendation to close this complaint.
This is Anthony. I make a motion. We accept legal's recommendation.
We have a motion by Mr. Harris. Do we have a second?
This is Fred. I'll second.
Second by Mr. Berry. Any other discussion? If not, Ms. Bohannon, please call the roll.
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Ron,
Yes.
Robert Shackelford.
Yes,
Mr. President, the motion passes.
thank you.
Item number 4 is complaint 2020-09-6301 against a funeral establishment with no disciplinary history. In December 2020, a board field representative performed an inspection of the respondent establishment. During the inspection, the representative discovered that the respondent's establishment license had expired on May 31st, 2020, and as of the date of the inspection, it had not been renewed. The respondent did respond to the complaint, and they apologized for their oversight. The respondent stated that they are a small business who does not conduct a lot of business, and due to the ongoing pandemic and paperless renewal process, they failed to renew on time. The respondent stated that this was the first time they have missed a renewal and will assure it will not happen again. Based on the time period, it's legal's recommendation to authorize for a formal hearing and authorize for consent order with a $500 civil penalty.
This is Fred. I just got a question. On matters such as these, is it typically a warning is not given and a fine would be given? I'm just curious as kind of past precedents on failing to renew.
Yeah, so typically we have been giving letter of warnings, but the periods are usually from about a month period. This was from May to December, so it's over 6 months. And with that, it's the statute indicates that there should be a civil penalty.
Okay, thanks. That helps out greatly. I'll make a motion to accept the recommendation.
We have a motion by Mr. Berry to accept council's recommendation. Is there a second?
This is Clark. I'll second.
Second by Mr. McKinney. Any further discussion? If not, Ms. Bohannon, please call the roll.
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Ron,
Yes.
Robert Shackelford.
Yes,
Mr. President, the motion passes.
thank you.
Item number 5 is complaint 2020-09-6581 against a funeral director with no disciplinary history. This was a consumer complaint alleging unprofessional conduct. The consumer stated that they contacted the respondent establishment inquiring about her grandson's services and that the respondent failed to disclose the information to her. The consumer additionally states that the respondent was unresponsive to their calls. The respondent did provide a response to the complaint, and they indicated the following: that the deceased mother and maternal grandmother arranged for the deceased services and informed the respondent that they did not want the father's side of the family to have any information regarding the services. The respondent stated that the consumer continuously harassed and threatened the respondent and others at the funeral home. The respondent also stated that following the services, the county sheriff's office had to be called due to threats of violence and presence of guns. The respondent also provided a letter written by the deceased mother indicating that the respondent conducted themselves in a professional manner despite the circumstances. It's legal's recommendation to close this complaint.
This is Clark. Motion to approve.
Motion to accept council's recommendation by Mr. McKinney. Is there a second?
This is Anthony, I'll second.
Second by Mr. Harris. Any further discussion?
I just had a question I'd like to ask. In a situation where you have a child's death, you've got a mother and a father, wouldn't the father have as much right for information as the mother? I hate that something like this escalated like it did and the conflict that was involved, but I just got a question about the legality of the father not being given information.
Our statutes and rules don't provide for that specific circumstance, but my understanding from the documents that were provided, it appeared that the mother's side had custody of the deceased, and they paid for all of the services. So I can't speak to providing information to the father's side. My understanding is that the father's side was given the information and that they did attend the services, and that is when the police did show up.
Okay, thanks.
You're welcome.
Any other questions or discussion? If not, Ms. Bohannon, would you please call the roll?
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes, Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Ron,
Yes.
Robert Shackelford.
Yes,
Mr. President, the motion passes.
thank you.
Item number 6 is complaint 2021-000-201 against a funeral establishment with some disciplinary history. This was a complaint submitted by a removal service alleging that the respondent's employees have been using the complainant's company's name under false pretenses to pick up and deliver bodies. The complainant stated that they have asked the respondent to stop and that the respondent has not. The respondent did provide a response to the complaint, and they indicated that the name they used by their internal transfer team is based off a geographical description of the area in which the respondent operates. The respondent states that they do not intend to enter the removal market and that they are not using the complainant's name under false pretenses. It's legal's recommendation to do a letter of warning here.
This is Fred. I'll move that we accept the motion for a letter of warning.
Motion by Mr. Berry to accept council's recommendation. Is there a second?
I second it, Scotty.
Okay, second by Mr. Porsche. Any other discussion? If not, Ms. Bohannon, would you please call the roll?
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Ron,
Yes.
Robert Shackelford.
Yes,
Mr. President, the motion passes.
thank you.
Item number 7 is complaint 2021-00-4141 against a funeral establishment with disciplinary history. This was a consumer complaint alleging unprofessional conduct. The consumer stated that as of the date of the complaint, they had not received the death certificate for their father, and they stated that the respondent has been unresponsive. The respondent's representative responded to the complaint, and they indicated that they informed the consumer that it can take 4 to 6 weeks to receive the death certificate. The representative stated that due to the pandemic, there have been additional delays in getting the death certificate. The respondent did provide proof that the consumer has since received the death certificate. The consumer also provided a rebuttal indicating that they had received the death certificate. It's legal's recommendation to close this complaint. I would like to note that it appears as though the death certificate was filed within the 5-day period. It just took additional time to receive the death certificate.
Was this a VRISM problem or county health department problem? Do you know what the holdup was?
I do not know what the holdup is. It does appear that it took 7 weeks instead of the required 6. It was 6 weeks. So it wasn't an extremely long period of time. They did not indicate what the delay was. They just indicated that due to the pandemic, there has been delays in them receiving the death certificates.
Thank you.
We know what county that was?
I can pull that up for you in one moment.
Yeah, I would think that if there's evidence that they filed it on time and it was definitely a
I believe it was Shelby County.
Shelby County. And that the delay was indeed, it would have either had to been with the doctor or the health department. You would think the delay would have been more with the doctor or something, but it seems like there should have been better communication to the complaint of what the reasoning of the holdup is, but that is an excessive time. But based on that, I'll move that we accept the recommendation.
Okay, we have a motion by Mr. Berry to accept council's recommendation. Do we have a second?
I'll second. This is Clark.
Second by Mr. McKinney. Any other questions or discussion regarding the matter? Not, Ms. Bohannon, please call the roll.
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Rom,
Yes.
Robert Shackelford.
Yes,
Mr. President, the motion passes.
thank you.
Item number 8 is complaint 2021-013381 against a funeral establishment with disciplinary history. This was an administrative complaint based on an anonymous tip indicating that they believed that there was a decomposing decedent at the respondent establishment. The individual stated that they believe the person has most likely been deceased for an extended period of time, and that the stench within is a strong, obnoxious odor with a deceased human as the stimulant. Due to the nature of these allegations, this complaint was immediately sent for investigation. In February 2021, a board field investigator conducted an inspection of the respondent establishment, and no violations were found. It's legal's recommendation to close this complaint.
This is Anthony. I'll make a motion. We accept legal's recommendation of closure.
Motion by Mr. Harris to accept council's recommendation. Is there a second?
Yes, Fred, I'll second.
Second by Mr. Berry. Any further discussion? Ms. Bohannon, please call the roll.
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Rom,
Yes.
Robert Shackelford.
Yes,
Mr. President, the motion passes.
thank you.
Item number 9 is complaint 2020-084551 against a funeral establishment with disciplinary history from 2012. This was a consumer complaint alleging unprofessional conduct and unlicensed activity. The consumer stated that in October 2020, they had contacted the respondent establishment regarding cremation services. The consumer stated that they had asked the respondent to retrieve the deceased from the hospital, and in the meantime, they completed paperwork. The consumer stated that 4 days later, they received a call from the respondent who indicated that they could no longer do the cremation. The consumer stated that the respondent informed them that they did not pick up the deceased and that they would be shredding all the consumer's information. The out-of-state respondent has not responded at this time. It's legal's recommendation to do a letter of warning, and if anyone has any questions on this one, I'd be happy to answer them.
This is Fred with with the past history, I don't know. I'm not sure if a letter of warning is sufficient, but I'll listen to others' comments.
This is Clark. If my memory serves me correct, this is one that we've had similar to this before. Maybe the same one that's out of state, that's trying to advertise on the internet. Was there nothing the Attorney General's office can do about them? If I'm recalling this correctly.
Tony, do you want to speak on what the Attorney Generals can and cannot do on this matter?
And this is some of the name. What, do we have the name of this one, or we haven't said the name of this one, Liz?
We have not said the name.
This is the one that you and I discussed?
Correct, yes.
Okay, thank you, that helps. I can do that without having to disclose it. Mr. McKinney, that was your question? Is that correct?
Yes.
Okay, yeah, so this matter, this is the one where it had a disciplinary history on there where the board had already found them for unlicensed activity. We have a civil penalty that's outstanding that's never been paid against the funeral home. It was not against the individual. We did send the activity actually continued. We did send that to the Attorney General's office several years ago, where they attempted to get service on the individual. The individual was apparently in hiding between Colorado and Florida, and they had difficulty serving that individual. And for the civil penalty amount that was actually against the corporation, the Attorney General's office indicated that it would that wasn't something that they were really willing to pursue at that point in time. What they had hoped is that there could be a civil penalty issued against the individual owner for this activity, and then if that had been issued at a hearing, then they could actually sue that person individually here in Tennessee, and that would be I guess, a better type case for them to take action on. That never actually happened. I know that several states have taken action directly against this individual, because this individual's website is not just hitting Tennessee, it's hitting multiple states. So there are attorney generals from other states that are taking action against this person. And when I say action, I'm really talking they're issuing civil penalties against them, which in my opinion, I don't think they're really ever going to collect these civil penalties unless somebody actually goes in and attempts to attach it to any piece of property that he may own individually, because the civil penalty amounts are routinely a little, kind of small. So this individual appears to continue on with some states getting some successes against him. He actually did at one point in time write a letter to our office threatening legal action for us, basically putting out a notice throughout the state saying that they were not licensed, and that essentially that they shouldn't be used. We sent that to the Attorney General's office. They essentially laughed at the letter and said they would respond back to it because they would love for him to sue us so that they could counterclaim on his continued unlicensed activity. So at this point in time, it's more of, I guess, a real bad way of putting it is whack-a-mole, honestly, because he comes up in other states. Other states have attempted to take some action against them. But when you're talking about an internet business, it's something that's extremely difficult to get to actually stop, because you have to actually get the individual who's not located in Tennessee. Last I knew that he was in between Colorado and the state of Florida. So I think to actually have something maybe take action, there would have to be a complaint against him individually, and then there would need to be a civil penalty issued by this board against him for a substantial amount. It would have to be over $10,000 for the Attorney General's office to likely take that case on. That may have been more than you wanted, Mr. McKinney. I apologize, but that is honestly the full history of it, because I don't think the board has heard the full history of it, because it has come and gone over the years.
Well, my memory serves me correct. I was right about that. Do we know whether or not is he having any success conning licensed funeral directors in Tennessee to do his work for him, or has word kind of gotten around?
No, I think so. That's a good question. I think yes, he's had some success in conning some funeral directors into it because I think these complaint I think we get complaints. Robert or Liz, tell me if I'm wrong. I thought we've received them before from funeral homes and also from consumers out there. But it's my understanding that I thought that some funeral homes in the past had actually used his service. But tell me if I'm wrong. If it's just consumers.
I think since I think the last complaint was in 2015, so so it's been 6 years since the complaint has been filed.
Okay.
So my understanding is currently funeral directors are not working with him.
Okay.
Robert might have better knowledge of that.
Right.
But in this, I think in this scenario that was an example of no one wanting to work with him, and that is why they were unable to continue with the services. And then the consumer was able to find a licensed establishment in their area to actually do the services for them.
Okay.
And the letter of warning comes from we don't really have any proof at this point that we just have this consumer complaint and there was no paperwork provided.
Right.
So
As far as calls to her office, they decreased drastically after the 2017 or 2018 notice that went out to the establishment, because I think that most establishments are aware of the aiding and abetting unlicensed activity. And I think that almost everyone has ceased their relationship with them. Of course, as Mr. Glandolf talked about, their mode of operation is to get the contact of the family, and then they contact a licensed funeral establishment / crematory in Tennessee and ask them to do a courtesy call. And, back a few years ago or several years ago, some of the funeral homes would participate in that because there wasn't as much information known publicly about the company and the individual that is now. So my understanding is it's almost zero. There may be an occasional occurrence. This complaint, as Ms. Mendel talked about, they accept, if anyone contacts them, they're going to accept it. But then when they can't find a provider to do it, then that's when they back out. And it's my understanding, in talking to some funeral directors across the state, that that's what's happened more recently than anything else, is they tell the family, which obviously it hurts the family because they think their loved one's being taken care of, and then they find out a day or two or 2, 3, or 4 days later that actually nothing has happened at this point. And then typically, like in this case, the consumer goes directly to a local provider who is licensed and has a brick and mortar business, and they provide the services. And eventually the consumer gets taken care of, the family gets taken care of. But obviously there's some problems in between the time that happens.
This is Fred. A question. Do we give a response back to the consumer to kind of let them know the history and why we can't really do anything more serious?
Yeah, I mean, we can draft that's actually a good idea. We can draft a letter saying that we have noticed that they've been operating on the internet for several years, and we've taken some forms of action, such as we have an outstanding order and civil penalty against them, and we can do that and tell them that we're continuing to monitor it. I think from the years that have gone on, I think the actual consumer harm has been low in the last several years. I think the annoyance to the consumer and the emotional toll that it takes having to deal with something like this is something that you really can't put a dollar sign on. But I think we can do that to let them know that this isn't something that we're just kind of brushing off. There's a lot of history to it.
This is Robert. Do we know the state where this entity is domiciled?
Yes, they're in their business address is in Colorado. The last state that took action was the state of Iowa back in February. Issued a $10,000 civil penalty against them for their continued acts in the state of Iowa. And that's what we had also was Colorado. And I think there's an issue with the Colorado's licensing laws that allows them to continue. It's a very open.
At one time, it seems that Colorado had sunsetted their laws pertaining to the funeral service regulations. I'm not certain if that's still the case, but I think
You may be right, Mr. Shackelford. I remember, I don't know exactly, but I remember when I looked at this years ago, there was an issue about it appeared to be like a lack of regulation on this for Colorado. Because that my initial assumption was that Colorado is the one who should take the most action since that's where they're domiciled at.
Thank you.
This is Clark. Is there, I don't know who this question goes to, if it's Ms. Bendell or Mr. Glandorf or Mr. Gribble, but is it possible maybe for this board or the department to just maybe send a reminder out about this organization, like, licensees do not fall prey to their scam?
I mean, I'll answer. I think, I mean, it would be another notice that like we had previously sent out. It would be something of that. It could be done. Yes. We do that through our media group.
Thank you.
Are there any further questions? If not, the board will entertain a motion as to the disposition of this case.
This is Fred. Is there any other options to a letter of warning that wouldn't create an administrative issue for the department?
We can do a letter of instruction, which is similar, just reminding them. I think the letter of warning is just to give notice at this point because we don't have really any substantial evidence. And then if another complaint comes in, I think we will evaluate our options at that point and see how we want to proceed forward there. And we can also, as you guys discussed, draft a letter to the consumers and then also reach out to the consumer who filed this complaint and give them a history of this matter.
To your knowledge, no monies were ever paid?
No, it was sent to collections in 2017. And then
I'm speaking about the particular request for cremation services.
Oh, no, they did not pay for the services. It was my understanding that everything was refunded and then all the paperwork was subsequently destroyed.
Can you disclose what part of Tennessee this occurred in?
Robert, do you? Oh, I know that the consumer indicated that they had found an establishment in Sparta, Tennessee after, so it's my understanding that it was that general area of Tennessee.
And just, I mean,
You broke up on me. What was your answer?
The consumer indicated that they eventually received services from a establishment in Sparta, Tennessee. So my understanding from that was that the general area would have been around there.
Of course, legal's on the phone, and they can advise better, but I think we have to be careful about discussing what area and what counties that such things happen, because I don't think the board wants to be, it appear that they're taking action based on what county it occurs. And I know that's important to the board members, and legal can speak to that, but I just, it may not make any difference. It may be something that we can divulge. And,
yeah, it's also important to note that this was internet based. So the consumer did, as Tony previously said, that the marketing is through the internet, and that's how they are getting consumers to try and get services. And then when they cannot find an establishment in the area where the services are needed, it seems that that's when they let their consumer know that they can't complete those services.
So I get, this is Clark. So basically the answer is this particular case was Middle Tennessee, but it probably in the past, it has happened in West and East also, probably.
Yeah.
This is Fred. To move things along, I kind of like the idea of a letter. You see, Ms. Mendel, you called it a letter of what?
Instruction.
Yeah.
So
That's right.
it's,
I think that would be better than a letter of warning myself.
Okay.
So I would make that motion.
We have a motion to request a letter of instruction to be sent. Do we have a second?
This is Clark. I'm assuming Mr. Berry is wanting the harsher of the two letters.
Correct.
Do we have a second to Mr. Berry's motion?
I'll second. This is
Second,
Clark.
Mr. McKinney. Any other questions or discussion regarding the matter? If not, Ms. Bohannon, would you please call the roll?
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Ron,
Yes.
Robert Shackelford.
Yes.
The board's recommendation passes.
Thank you, Ms. Bohannon.
and that completes the legal report for today.
Thank you, Ms. Bendale. Next item on the agenda is the Executive Director's Report. Mr. Gribble.
Good morning, board members. First of all, I want to apologize that the Connect information was not there on the website and available so we could start on time this morning. We will make sure that we check on that in the future and hopefully that will not happen again. First thing to look at is the legislative update. And we have several bills. Some of these are directly related to the Board of Funeral Directors and Embalmers, and some of them will just be indirectly related, but it's information we want to give you and provide to you. And then before we start going through those, I want to call your attention to the very bottom, which is the website for legislative bill searches. You can go there on your own and search for any bill and what it affects and how it affects, and find the bill number and the contents of the bill and that information. But the first one this morning is House Bill 0780 and Senate Bill 0771. This is an administration bill that we've talked about previously, and what it does for the funeral board is it changes the 40 hours that a apprentice is required to work. It reduces it to 32 hours so that someone who is working a current job and hoping to be able to get a funeral director's license might be able to serve their apprenticeship by working less number of hours per week. It also, as far as burial services, will exempt some funeral directors from being required to register as pre-need sales agents. House Bill 0334, Senate Bill 0931. It imposes requirements on the operation of alkaline hydrolysis facilities and the use of alkaline hydrolysis in the state. House Bill 1181 and Senate Bill 0828. As introduced, it requires the disposition of aborted fetal remains to be by burial or cremation. It requires the Department of Health to promulgate certain rules and forms and make certain other changes regarding the disposition of fetal remains. It does amend Title 62, Chapter 5, which is the Board of Funeral Directors and Embalmers. House Bill 0788, Senate Bill 1429, as introduced, requires this state and the county in which the person resided to pay up to $2,000 for the burial or cremation of a person who dies from COVID-19 if the person's family is financially unable to pay for proper burial or cremation of the person. House Bill 0738 and Senate Bill 1091, as introduced, reduces from 100% to 80% the amount of funds received for funeral services and merchandise to be held in trust pursuant to a pre-need funeral contract funded by trust deposit. It requires the contract to disclose to the purchaser in boldface type the percentage of funds the seller is required to trust, along with the name of the trust officer, the trust institution, and their respective addresses and phone numbers. House Bill 1466, Senate Bill 1558, as introduced, reduces from 75 to 60 days after the end of the pre-need seller's fiscal year, the time by which a pre-need seller and trustee must file an annual report with the Commissioner of Commerce and Insurance. House Bill 0012 and Senate Bill 0951, as introduced, enacts April's law to clarify that a person who engages in sexual contact with a corpse commits the offense of abuse of a corpse, a Class E felony, requires law enforcement officers to ask victims of stalking, domestic abuse, or sexual assault whether the victim requests the defendant to be required to wear a GPS tracker if released on bond. I do know that that bill has been amended to delete the latter part of that. It still requires, the amendment does not delete the part about the corpse and a Class C felony. So those are the bills that legal and I are aware of that we thought would be of interest to the board. If you have questions, I'll be glad to answer those, or legal would be glad to answer them, or we can go on through the report and answer them at the end, whatever if you have them. Next is a report of licenses administratively approved by the executive director to present to board authority for the period of February 6, 2021 through March 5, 2021. You have a list of those licenses there of the individuals that have been approved. Closed establishment report. We have 2 establishments that reported closing since the last board meeting. That's Gibson Funeral Home at 403 Roselle Street in Gibson, Tennessee, and Mercer Brothers Memorial Chapel at 85 Barnhill Street in Lexington, Tennessee. A complaint report. As of March 5, 2021, there were 11 complaints involving a funeral director and or embalmer, and 20 complaints involving an establishment, for a total of 31 complaints. And again, we'll be glad to answer any questions that any board member has. As far as disciplinary action report, there was no disciplinary action to report to you, so that was the reason I didn't mention that. There was nothing applicable on the disciplinary action report.
Thank you, Mr. Gribble. Does anyone have any questions regarding the executive director's report?
I cannot remember. Do we have to have a motion to accept those?
Yes, we do.
I so move.
Second, that's Clark.
We have a motion by Mr. Berry and a second by Mr. McKinney to accept the executive director's report as presented. Any further discussion? If not, Ms. Bohannon, please call the roll.
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Ron,
Yes.
Robert Shackelford.
Yes.
President, the executive report has been accepted.
Thank you, Ms. Bohannon. I believe we have an application for an establishment license to come before the board today, and we have present with us Ms. Tiffany Widener, who will be the manager of this proposed facility. And Ms. Widener, would you like to share some opening remarks with us?
I would. Thank you so much for having me today. I appreciate all you do, each and every one of you, to keep our profession safe. And I know it is, it's a task. And I've watched these board meetings, and I'm very appreciative of all you do. I'm thankful to be here today. I would like to share a little bit about my history. I'm a bit of a storyteller. I think it helps you understand the full, so just bear with me just a little second. I want to share with you how I got into the industry, but I have to go back a little bit. I'm not going to birth or anything, but at 18, I was involved in a very serious car accident, near fatal car accident. And when I say near fatal, I mean I almost passed away. And I'd love to be able to tell funeral directors this because you get it. My C1 and my C2 was broken in my, so, but it did not break the spinal cord. Praise God. So that's why I'm able to be here today. So with that said, I was actually on my very first date with my husband at that accident juncture in life. And needless to say, the for better or for worse, we got the worst out of the way in the beginning. We got married. Let's fast forward 10 years later. My husband is now a police officer and for Metro Nashville. And I know you all are Tennesseans, but I don't know how far back you go in your roots. But Officer Christy Dedman, when she was killed in 2004, if that name rings a bell to you, she worked with my husband at the police precinct, and it was her funeral. She was killed in the line of duty. She stopped, didn't even have a call to go to that stranded motorist, and she just stopped because it was the right thing to do, and she lost her life that day. She'd been on the department 1 year, and at 34 years of age, she passed away. So of course, my husband and I went to that service, and I can't say that it was the service itself or if it was just a culmination of things going on in my life, and almost passing away 10 years prior myself, and being 28 at the time, and realizing Christy was 34 when she passed away, but yet she had this dream to become a police officer, and she'd only been on a year. So, I mean, she met her dream. She embraced it at like 33, 32, 33, and I was 28. And what was my dream? And my husband and I had adopted this beautiful biracial little boy at birth 3 years prior, and here I was, a mom, wanting to be everything for him and help him in life to pursue his dreams. And I was like, gosh, this has to start with me. But that wreck sidetracked me for years. I had a reconstructive facial surgery every year from 1994 until 1999. So, life was kind of put on hold for me during those like formative years where you're figuring out who you are and what do you want to be. So, I was a mom, and that was wonderful, but I wanted to have my own pursuits to show him how to do it. Yeah. So that's why I say you kind of got to go with me through all this. So I was so like impassioned by that moment, and I started researching, this profession, and I had been through so much, and I feel like I'm, have been through things, and I can relate to people compassionately. And I realized there's a school here in Nashville, John A. Gupton, and the very next year I was enrolled. So while in school, I completed the education. I was the valedictorian 4.0. I received the Tennessee Funeral Directors Association Full Scholarship that year. I also received the 100 Black Women of America Scholarship. I also received a scholarship to attend the NFDA's Professional Women's Conference the following year. So I was impassioned, but I also had a baby during the middle of mortuary school. Praise God, 10 years later, I'm like, why now, Lord? But okay, I'm going to do that too. So bear with me. I just keep going. After I graduate John A. Gupton in December, I continue my education and get a bachelor's in business management and human relations from Trevecca while I'm doing my apprenticeship. Then I eventually start at SCI, and I started as a part-time receptionist, and I was so excited to get in, and within 6 years, I worked my way up to a location manager. And while I was doing that, I also received my graduate degree in public service administration. So I'm all about keeping on and doing whatever it takes. And I believe that even though those first years of my adult life were hard and difficult, I have faith that there is a God who is there then and now and always will be through the difficult moments in life. And with divine providence, I believe that last year, as difficult as it was for everybody, everything in my past, my professional life, and everything just aligned perfectly as I was introduced to be able to help create Lumen cremations. So it's just been an honor to go and do this, and just embrace all the dynamics that it takes to get a business started for the community, and all of the community entities that have to play a part in that. And so it's just been rewarding for me to be a part of this and to know that the other end of that is a service that helps people and that I get to help people. And that is my passion in life. And that's what I'm here today, is to just request that you approve this business and this opportunity to be another option for area Nashvillians, Middle Tennesseans, however you want to put it, to have as a resource, to be a help at one of the most difficult times of life. And I'll be honored to serve them. And I'm honored again to ask this of you today. And thank you again for all you do.
Thank you, Ms. Widener. Does the board have any questions for Ms. Widener?
Mr. President, I've got just maybe a series of questions just to clarify from our paperwork that we've got, and I appreciate Ms. Widener's comments. On our paperwork, we have that this establishment is going to offer direct cremations only. Then, yet in our photographs, we have pictures of a couple of caskets, maybe in a selection room, and then a chapel. Has that changed, or are we looking at the wrong pictures?
I think you're looking at the wrong pictures, because we don't have any caskets or a selection room.
Okay, thank you. Did everybody get the same pictures I got?
Yes, I did. I'm looking at an area that looks like a chapel with pews in it, and also a picture of two caskets, one stacked above the other on the right.
No, that's not ours. I'm sorry.
Mr. Shafford,
Yes, sir.
Bill representative that did the inspection had some computer problems. And I think probably those two photographs, it was confusing to me as well as to how that office complex as it's laid out could contain those. I think that's what I think that there's been two photographs that are uploaded there that aren't. Do know that the other photographs are correct. If we go to the photographs, look at the and I know Ms. Widener doesn't have access to what the board members have, but let me if you go down to the first photograph, which is on page 20, 21 and 34, I guess, in the PDF. That's and when I start talking, Ms. Widener, you can probably expound upon it. But that is a picture where there's a wooden gate at the front. It's my understanding that that's the entrance that the establishment plans to use, and the public can go directly from the parking lot into
Yes, sir.
that area and come inside the building.
Correct.
And the next photo you have is made of the door that you would enter in that area. The next photo is from a different area of the complex. Ms. Widener, it's the one that says 7978 and has the arched opening. It has the handicap access to it. Appears to be a rail from the outside. So that's a different entrance, correct?
Yes, sir.
And then as you go in that door, then you'll see Suite 101. You'll see a photo of Suite 101. The next one is a photo, and I'm 99.9% sure that that's correct because it looks like it has the same logo. The inside has it has some green in it. The wall has some green in it. There's a desk and a office chair. And
Yes, sir.
then the next one is also on the inside of that building where it has a high top table with two seats at it near a window and a desk and another chair to make arrangements. So then it's 27. That photo is not applicable. The next one is because you can see the urns and you can see their logo there on the wall and a round top table, I assume, where you're going to make arrangements and do your conference with your families.
Where I'm sitting right now.
Yeah, okay. And then Looks like there's access to, you have access to a kitchen or kitchenette or something like
Yes,
that?
sir, we do.
And restroom
Yes, sir.
facilities. So those, and then obviously the 32 out of 34, then it has 2 caskets, is not that one. Or the 33 out of 34 is not that one as well.
Well,
Hope
that
that
may be interesting.
Mr. President, for the record, and since people are listening virtually, the name of this business, and tell us how to pronounce it, Ms. Widener. How do you pronounce
Lumen.
it? Lumen?
Lumen Cremations.
Lumen Cremation LLC. It's located at 7978 Coley Davis Road, Suite 101, Nashville. The owner's a limited liability company, and it's Lumen Cremation LLC at the same address as the owner.
I had a question about a letter that is a part of the application packet. I believe it's on page 15 in the packet. It is a letter from Music City Mortuary signed by Jeffrey L. Murphy. It's dated January the 14th of 2021 and addressed to Mr. Gribble at the State Board of Funeral Directors and Embalmers. And it states that this letter is to confirm that Music City Mortuary has agreed, I'm assuming to provide, that's not included in the letter, but I would make that presumption based on the language, that they've agreed to provide embalming, preparation, and related funeral support services for the proposed funeral establishment, Lumen Cremation. And then they go on to state that they will also provide cremation and related services. And that may just be a form letter that they send out in situations like this, but I know Mrs. Wyden, you have indicated that you do not plan to provide any type of funeral services, but I'm just curious as to that letter and its content being a part of your packet.
Yeah, I think that was a typical form letter, but we are not doing anything but the direct cremations.
So if you were approached by a family to provide what we might consider a traditional funeral service or some variant thereof, then you would decline that
That is
opportunity
correct.
service.
That is correct.
Thank you.
This is Fred. I've got a question. Will you be giving families the opportunity to view their loved ones? And if so, where will that occur? Or will families not be given any opportunity to view or make a visual identification?
They will have the ability to make a visual identification if they so choose. We are going to work with Music City on that, or if they want to witness the cremation. I know some religions, request that. So we have made provision, in the GPL for that as well. So yes, sir, we will make that happen at Music City. So.
Okay, thanks for clarifying that.
Yeah, absolutely.
This is Anthony. I got a quick question. Ms. Widener, when the folks enter your establishment, will they be coming straight into your entrance, or from the picture, it looks like there's multiple offices in that complex?
It is all owned by the CEO of Lumen. It's all their building. The office that we are using that people would walk into is strictly for Lumen. It is only Lumen.
Thank you.
Okay, this is Clark. That was, I was going to ask basically the same question, I guess. Is your business the only one in that building? Or are there multiple businesses in that particular building?
It's the owner of Lumen. They have a business, and then my specific office is just strictly Lumen. And it has its own direct access from the parking lot as well. So there's no reason for anybody to enter any other part of any business. And we have signs, we don't have them up yet, but we have signs that we are, as soon as approval ready, we're going to get posted, and we're actually working with a monument company too to get a monument outside. So.
So this is Fred. So the entity Lumen operates other businesses other than operating this new cremation business.
No, it's just Lumen. Do you want to speak to the owner?
No, that's not necessary. I was
Okay.
a little bit confused as to whether Lumen was a name also used for other businesses. So I was just trying to clarify that.
No, it's just the owner's building, and they have renovated an office space just for Lumen. So, and Lumen that is all the name is, Lumen, for Lumen Cremation.
Ms. Widener, would it be fair to
Yes.
say that any other business operating in that complex is related to funeral service? Although it's not aluminum, is it related to funeral service?
No, sir. Not in
Okay.
directly. No.
This is Fred. It seems to me that they meet all the requirements for an establishment. So I'll make a motion to approve.
We have a motion by Mr. Berry to approve the establishment license application. Do we have a second?
I will second, Scotty.
All right, we have a second by Mr. Porsche. Is there any other discussion, any other questions? If not, Ms. Bohannon, would you please call the roll?
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Rom,
Yes.
Robert Shackelford.
Yes.
Mr. President, the motion passes.
Thank you, Ms. Bohannon, and congratulations, Ms. Widener. We wish you
Thank
the
you
best.
so very much. Thank you. I appreciate you all. Thank you so much. I appreciate all you do. Really, I do.
Thank you. Is there any new business that needs to be brought before the board this morning? If not, we will entertain a motion to adjourn at 11:36.
So move. This is Clark.
We have a motion by Mr. McKinney. Do we have a second?
Fred second.
Anthony, second.
We have multiple seconds. So if there's no further discussion on the matter, Ms. Bohannon, will you call the roll?
Fred Berry,
Yes.
Anthony Harris,
Yes.
Tanya Haynes,
Yes.
Clark McKinney,
Yes.
Scotty Porsche,
Yes.
Charles Rom,
Yes.
Robert Shackelford.
Yes.
Mr. President, the meeting is adjourned.
Thank you, Ms. Bohannon, and thanks to everyone for your attendance today, and we wish all of you a great week.
Thank you.
Thank you.
Bye-bye.
Bye-bye.